Just when we thought that the whole fight between DeSantis and Disney over the Reedy Creek Improvement District, their company town in the center of Florida, just when we thought that was over, we thought, hey, look, the power is going to transfer peacefully from one entity, from Reedy Creek, to the Central Florida Tourism Oversight District, which is the new state-led, state-appointed district. Just when we thought, hey, that's the end of the story, we're done here, we are not done with this story. There is a massive development as Disney attempted a secret power grab, an underhanded power grab before the transfer of power. As they knew they were going to lose control, Disney and the Walt Disney Company directed its cronies, its lackeys on the board of Reedy Creek, the old Reedy Creek, to sign agreements, to sign contracts, as well as place real covenants, restrictions on Reedy Creek property in order to slow down, in order to impair what the oversight was going to be over the district, in order to impair the actual laws being enforced against Disney, in order to stop Disney from having to play on the same playing ground as every other special district, every other company in Florida. Disney couldn't have that, so they decided to fight dirty. We're going to get into it today. As always, I am Andrew Esquire. This is the legal mindset where we teach you to be your own judge. And about myself and why I'm so fired up with this is my area of expertise. As a Florida attorney, I practiced for nearly a decade in the realm of special districts. Special districts were my forte. I have worked across the table from Reedy Creek Improvement District. I have signed contracts with Reedy Creek Improvement District. I'm very aware of the people working there, of the attorneys working there, and of their underhanded tactics. And believe you me, there is no love lost between me and the rat. But that being said, I still go by the law and what the law is. And in this latest turn of events, we're seeing Disney actually go completely against what the law is in Florida. And they're trying to, through a backdoor way, maintain power. They're trying to hold on to those powers that they had over their fiefdom. Remember, as a recap, Disney essentially was running this area that's larger than San Francisco, in the city of San Francisco. This area, they were running it as their own city. They set the rules. They set the taxes. They set all the restrictions, the regulations. When they needed to do something, Disney went and asked Disney. They didn't have to go ask the city or the county. And look at Universal, same sort of theme park. They want to do something, they got to ask the city. They got to ask the county, right? They've got to go get approvals to do what they want to do. But Disney was running their own show. It's an unfair leg up that Disney has had for, well, a long time. Let's say, almost 75 years at this point. It's been a long time. So Disney finally was going to have some oversight, some transparency. They were going to play by the same rules. So what did they do? They ended up signing these developer agreements. Now, developer agreements are a very specific thing that you can do under Florida law regarding potential development or redevelopment of an area. And those are agreements between developers, typically land developers, who are coming up to naked, barren land. They're going to build something there. And they're saying, hey, look, in exchange for us building this here, let's agree to stuff up front. Let's agree to things so we can speed the development of this property. That's a developer agreement. And it's generally beneficial to enter into developer agreements to expedite the development of undeveloped areas. And these are binding to an extent, and that's the key here. These are, to an extent, binding on local governments. So when a private entity and a government enter into a development agreement, to a certain extent, they're binding. However, they're not impenetrable. And this is what Disney and Reedy Creek entered into, a developer agreement. Also, they placed restrictive covenants on the property. Now, for those who may not know, restrictive covenant is the same thing that your homeowners association or HOA places on your property if you live within the bounds of an HOA. So one covenant that you may be familiar with to your HOA is the covenant to pay them maintenance fees. So if you're in an HOA and you're paying a maintenance fee, you've probably got a real covenant on your property, which is contained in what's called the declaration. And that says you've got to pay them property for them to maintain things. You also may have other ridiculous restrictive covenants on your property placed by the HOA. Maybe you've got to plant certain type of trees. Maybe you've got to keep your grass a certain length, or maybe there's certain colors you can't paint your house. Like, hey, don't paint your house purple or pink. Those are the type of restrictive covenants you might see on your property. You might also have some weird architectural review board that's got to approve everything that's got to be done or is done to your house. These are the typical sorts of restrictions that are called restrictive covenants, and they're placed on your property. They're actually placed in the property itself. Now, there's problems with both Disney trying to seize power from Reedy Creek by developer agreement and by contract. These are two separate things. So I'm going to break those out. But before I get into those problems, guys, if you like this content, if you're enjoying my breakdowns, make sure you smash the like button right now. Make sure you are still subscribed, because YouTube is unsubscribing people. So ding that bell, ding that notification bell, and leave a comment on this video, hey, if you like this sort of content. So let's get into developer agreements. So developer agreements, those agreements that are between a government and a private developer, well, they're not impenetrable. Here's why. You can look at the conditions that may have changed since the initial type of development. And if you spend even a second worth of statutory research, you see this. And we'll click over here and we'll show you the actual statutes related to development agreements, which is 163.3233, which is local laws and policies governing a development agreement. Well, if you've enacted a development agreement, right, and you've gone and entered into this, well, does that mean that the local government's laws and policies don't apply? Well, no. There's actually certain conditions upon which they can apply. So if the local government, i.e. the new Central Florida Tourism Board, holds a simple public meeting and finds any of the following, then that development agreement is null and void. It's gone forever. So let's see all of the things they could find here, and any of which would allow the Central Florida Tourism District, would allow them to override those provisions and override that secret Disney power grab. So if, let's say, that agreement that was enacted in bad faith is in conflict with laws and policies that exist regarding development agreements, and if it's in any way preventing the development of land, well, you might find that it's in conflict with some existing policies or perhaps some new policies. You can have right here that under D, and I'm skipping over B and C because public health, safety, welfare, that's kind of ambiguous. If you specifically anticipate or provide for exceptions, okay, that's there. But going down to D, and then we'll get to E. If we go down to D, we see if the local government demonstrates substantial changes that have occurred in pertinent conditions existing at the time of approval of the development agreement. Hold the phone. You know what's a pertinent change between when this was enacted in February and now? Let's see. How about turning the entire power over? How about the entire board flipping? How about the scam being up? The rat has been run out of town. This sham control is gone. That is a material change condition. This turnover is a change condition. And the bad faith involved in that turnover, I'd argue, is a substantial condition to consider regarding this development agreement. But then, this is even better. And once again, remember, ladies and gentlemen, we only need one of these. We only need one, and we can override this. Let's continue with E. The development agreement is based on substantially inaccurate information supplied by the developer. Do you think Disney was being honest in everything they put up and put forward? No, they've been dishonest and disingenuous the entire time. I guarantee you that the information that this was based on, signed on, was inaccurate. In addition, I think that the bad faith undermines this as well. I think that absolutely undermines the accurate disclosure of information. So you've got a lot of factors here, any one of which, mind you, can turn this over. But let's go down here even further under 1633235. A local government shall review land subject to a development agreement at least once every 12 months to determine if there has been demonstrated good faith compliance with the terms of the development agreement. And this is where I think we can get in trouble. If we're talking about good faith and bad faith, and you look at Disney, there's been nothing but bad faith in their dealing with this entire exchange of power. Disney has again and again tried to wiggle and lie and cheat. And this is another weak attempt by them to get out of this transfer of power. So I absolutely think that that provision could apply as well. But let's go over to real covenants. Now, real covenants. Hey, listen, why would a real covenant not apply, Andrew? Come on, they got them, right? It's on the property. It's a real covenant. You can't fight a real covenant. No, that's wrong. Now, while if you live in an HOA, that HOA might ban you from having a purple house. Let's say the city exercised eminent domain. They took a property, right, for their own uses, and they wanted to build a school there. And they decide to paint that school purple because, hey, your team mascot is the Purple Dragons, whatever, right? They want to paint it purple. That restriction does not apply to the government. Cities, counties, and special districts, which are supposed to be governments, public entities, not private entities, they are not bound by real covenants. So they can just say, Disney, go suck on a lot of these nuts in this issue. They can say, look, we're not going to deal with this. You cannot bind us. We are a government. We are not going to follow your real covenant. It is not binding upon us. And I think they can find a way to get past those real covenants because they're a public entity, not a private entity. And certainly they're going to be able to challenge the way they were inducted. There's multiple requirements, notice requirements, public hearing requirements, newspaper requirements. And if Disney was able to put these things out there without notice, or if they did it without notice, that would also void the development agreements, also could avoid the real covenants, depending on how they enacted them. So there's multiple other ways to get rid of this. That's why I believe firmly that Disney's secret power grab will fail. I'm going to stay on this one, and I have an active public records request to get the actual documents, to get all of those so I can review them and do a deep dive. As always, this is my area of practice, so I'm happy to see this continue so we can expose Disney's BS. That being said, take care. Make sure you smash the like button. Catch you later.